Hello everyone, I'm Rong, a Chinese lawyer. Today I want to talk about the nature of a contract determines directly the amount of remuneration. In this case, after the court determined that the nature of the contract signed by the plaintiffs and the defendant was a brokerage contract, the plaintiffs were entitled to a remuneration of 20 million RMB, far exceeding their requirement before litigation. Okay, let me introduce the facts of this case. This case involves three parties. The first party is Wanjia Financing Consulting plc, which was registered and incorporated in British Virgin Islands. Hereinafter, I will call it Wanjia. The second party is Mr. Ye, who is a Malaysian. The third party is Zhongyu Building Material Co. Limited, which was registered in Nan'an City, Fujian Province, China. Hereinafter, I will call it Zhongyu. On February 26, 2009, Wanjia and Mr. Ye concluded the financing services and confidentiality agreement with Zhongyu. According to this agreement, Wanjia and Mr. Ye would introduce investors for Zhongyu to raise funds, and Zhongyu would pay the financing services charge of 9% of actual investment amount in two phases. That is, the first 4% would be paid in cash or by remittance within 14 days after the capital injection was completed, while the other 5% would be injected directly into Zhongyu or a listed company designated by Zhongyu as investment funds. According to this agreement, in addition to introducing investors, Wanjia and Mr. Ye also should provide other financing consulting services to Zhongyu. They should assist Zhongyu in completing the following matters like preparing business plans, packaging business, standardizing and improving relevant legal and financial matters, and preparing legal and financing documents, coordinating and responding to the investors' due diligence, negotiating investment terms, maintaining the relationship between Zhongyu and investors, etc. After the agreement was signed, Wanjia and Mr. Ye successfully introduced investors to Zhongyu, and Zhongyu actually received an investment equivalent to RMB 200 million. But Zhongyu failed to pay the remuneration to Wanjia and Mr. Ye. The reason for refusing to pay was Zhongyu believed that Wanjia and Mr. Ye did not perform all the obligations stipulated in the agreement. Subsequently, Wanjia and Mr. Ye sent an email to Zhongyu for negotiations, and they even proposed that their final remuneration for completing the work would be 50% of the total remuneration agreed in the contract. But Zhongyu still refused to pay, resulting in a dispute. Finally, Wanjia and Mr. Ye filed this lawsuit with the High Court of Fujian Province, China, and requested the court to order that Zhongyu should pay all the financing service charge in arrears and the interest thereof. Here, I want to emphasize that this case was filed directly with the High People's Court in Fujian Province in 2012. Because the subject matter of this lawsuit was near 37 million RMB. However, according to the current regulations, with this amount of the litigation, a first instance lawsuit cannot be filed directly with the High Court. In my previous video, I explained in detail with which Chinese court you can file a lawsuit for your foreign-related civil or commercial cases. If you are interested, you can watch that video. I have already attached the link below. This case went through 2 stages, the first instance and the second instance, and the second instance court set aside the first instance judgment and ordered that Zhongyu should pay Wang Jia and Mr. Ye the remuneration with amount of 9% of the total amount of funds raised, which is 18,280,753 plus the corresponding interest. Next, I will explain the 3 issues in this case one by one so we can understand why the second instance court changed the first instance judgment. Okay, the first issue is, what is the nature of the agreement involved in this case? A brokerage contract or a service contract? The defendant Zhongyu believed that it was a service contract for the following reasons. Firstly, the name of this contract was Financing Services and Confidentiality Agreement. The second reason is, it was also stipulated in the agreement that Wang Jia and Mr. Ye should provide financing consulting services to Zhongyu. However, both the first instance court and the second instance court held that the nature of the agreement was a brokerage contract. The reason was, the main purpose of the agreement is for Zhongyu to obtain the investments and for Wang Jia and Mr. Ye to get introducing fees. All financing consulting services are designed to achieve this purpose. The contract in this case complies with the description of a brokerage contract in the contract law of the People's Republic of China. An intermediation contract is a contract whereby the broker presents to the client an opportunity for entering into a contract or provides a client with intermediary services in connection with the conclusion thereof, and the client pays the remuneration. So, the nature of the agreement involved in this case is a brokerage contract. The second issue is whether Wang Jia and Mr. Ye have fully performed their contractual obligations or not. Zhongyu believed that they did not. Even Wang Jia and Mr. Ye stated in their email before the litigation that the final remuneration for the work they completed was 50% of the total remuneration stipulated in the contract. Of course, their negotiation proposal was not recognized by Zhongyu, leading to the lawsuit. The first instance court held that for Wang Jia and Mr. Ye, introducing investors to Zhongyu was the main contractual obligation, and the consulting services were incidental obligations. Because Wang Jia and Mr. Ye did not fully perform the incidental obligations, so the claims of Wang Jia and Mr. Ye were partially supported. The first instance court ordered that Zhongyu should pay Wang Jia and Mr. Ye the remuneration of 5% of the amount of investment. But the second instance court held that as long as Zhongyu received investment due to the introducing of Wang Jia and Mr. Ye, Wang Jia and Mr. Ye had fully performed their contractual obligations, and hence they had the right to claim the corresponding remuneration according to the contractual stipulations. In other words, Wang Jia and Mr. Ye could claim the remuneration of 9% of the total amount of funds raised for Zhongyu, because the purpose of this agreement is to get the investment. The third issue is the remuneration stipulated in the agreement clear? The agreement stipulated that the 4% of the amount of actual investment should be paid in cash or by remittance, while the other 5% would be paid in non-cash form, which was the second part of the remittance would be injected into Zhongyu or a listed company designated by Zhongyu as investment funds. It was difficult to realize because of the obstacles in terms of the company law. So, the first instance court held that the remuneration stipulated in the agreement is unclear. But the second instance court did not believe so. They held that although the second part payment method is difficult to realize, it does not affect the total amount of remuneration that Wang Jia and Mr. Ye should get according to the agreement. Therefore, the second instance court determined that 5% of the remuneration should be paid in the same method as 4% of the remuneration. That is, the 5% of the remuneration also should be paid in cash. This case has great significance in protection of brokers' right to claim remuneration. In the international trade, a broker who provides investors or fundraisers with brokerage services should have the legally protected right to claim remuneration.